The Supreme Court is about to decide a case that could quietly but dramatically change who can legally own a firearm in the United States. And almost nobody outside the legal world is talking about it yet. The case is called United States versus Khamenei, and at the center of it is a federal law that most gun owners don't realize even exists until it's used against someone. That law is 18 U.S. Code, Section 922, subsection G, paragraph 3. It makes it a felony for any person who is an unlawful user of a controlled substance to possess a firearm. On its face, that might sound straightforward, but once you dig into how that law is enforced, how vague it is, and how it fits into the Supreme Court's modern Second Amendment framework, things get complicated very fast. And that's exactly why the Supreme Court stepped in. Here's the core question the justices are being asked to answer. Can the federal government permanently or semi-permanently strip someone of their Second Amendment rights based solely on drug use, even if that person is not intoxicated, not violent, and not committing any other crime at the time they possess a firearm? That question goes far beyond drugs, because if the government wins here, it reinforces a much broader principle: that Congress can declare entire categories of people prohibited from owning firearms, even when there is no historical tradition supporting that restriction. And if the government loses, it sends shockwaves through every prohibited person law currently being challenged in federal courts. The facts of the case are simple. Khamenei was charged under Section 922 G3 for possessing a firearm while allegedly being an unlawful user of a controlled substance. Not while intoxicated, not while committing a violent offense, not while using the firearm in any way, just possession. The government argued that drug users, as a class, can be disarmed because they are presumptively dangerous. Lower courts accepted that reasoning for years. But then came the Supreme Court's decision in New York State Rifle and Pistol Association versus Bruen. Bruen changed everything. Under Bruen, courts are no longer allowed to balance public safety against individual rights. They can't use interest balancing, and they can't rely on modern policy arguments. Instead, the government must prove that a firearm restriction is consistent with the nation's historical tradition of firearm regulation. Not loosely related and not vaguely similar, but actually rooted in history. And that's where Section 922 G3 runs into serious trouble. There is no founding-era tradition of disarming people simply for using alcohol, opium, or other intoxicating substances. In fact, during the founding era, alcohol consumption was widespread. Opium and laudanum were legal and commonly used, yet there were no laws permanently disarming people for using them. There were laws punishing misuse of weapons while intoxicated. There were laws against violence, but not blanket bans on possession. So the government had to get creative. In Khamenei, the federal government argued that drug users are analogous to historically disarmed groups like the mentally ill or dangerous persons. The problem is that analogy is doing a lot of work, because modern drug laws didn't exist at the founding, and the idea that drug use automatically equals dangerousness is a modern assumption, not a historical one. Several federal courts have already rejected that logic. The Fifth Circuit struck down Section 922 G3 as unconstitutional. Other courts have followed, some courts haven't. And that split is exactly why the Supreme Court took the case. This isn't just about drug users, this is about how far the prohibited person category can be stretched. If Congress can disarm people based on status rather than conduct, then the Second Amendment becomes conditional. And conditional rights are not rights at all. The government insists that this law is necessary for public safety, but Bruen made clear that necessity is not the test. History is. The Supreme Court now has to decide whether courts are allowed to invent historical analogies where none actually exist. If the court sides with Khamenei, Section 922 G3 could be struck down entirely or limited dramatically. That would immediately affect thousands of pending cases. It would also embolden challenges to other prohibited person laws, including bans affecting nonviolent felons, restraining order respondents, and other status-based disqualifications. If the court sides with the government, it signals that Bruen has limits. that courts can still defer to modern legislative judgments as long as they can gesture vaguely toward historical concepts like dangerousness, and that would slow or even reverse the momentum Second Amendment challengers have had over the last 2 years. There's another layer to this case that hasn't gotten much attention. Enforcement. Section 922, G3 is notoriously vague. What does unlawful user mean? How recent must the drug use be? Does it require addiction? Does it require intoxication at the time of possession? Federal courts have answered those questions differently. In some cases, a single admission of past use was enough. In others, prosecutors relied on text messages, social media posts, or third-party statements. That kind of vagueness raises serious due process concerns, and the Supreme Court has not ignored that in other contexts. So this case isn't just a Second Amendment case, it's also a warning about how easily vague laws can be used to strip constitutional rights. The outcome of Himani will likely be decided sometime next term, with a ruling expected by summer of next year. But the signal the court sends could come much earlier, during oral argument. The questions the justices ask will tell us whether they see this as a narrow case about drug use or a broader case about the limits of government power over fundamental rights. Either way, this case matters, because it answers a simple but dangerous question. Does the Second Amendment protect people or only the people the government approves of? And once that line is crossed, it's very hard to uncross it. And this is one to watch closely, not because it's flashy, but because it goes straight to the foundation of modern gun law in America. And whatever the Supreme Court decides here will echo far beyond this one statute.